Don't make this difficult, Nora. Your brother just got out. He needs somewhere stable to land. You have more than enough space for one person. My aunt stood in the entrance of my condo, arms crossed, wearing that expression she always saves for when she's about to tell me what I owe someone. She had let herself in with the spare key I gave her 3 years ago for emergencies. My brother stood behind her in the hallway with 2 duffel bags, and a smirk that told me this had been planned for a while. You can stay at your friend's place tonight, she said. He needs the quiet. She walked back inside and closed the door between us. I stood in my own hallway holding my grocery bags, listening to the deadbolt click from the inside. Before I tell you how I ended this without raising my voice once, tell me in the comments, what is the most entitled thing a family member has ever done to you? I read every single one. I drove to my friend's place and slept on her pull-out couch. It was fine. Clean, warm, a good neighborhood in East Vancouver. But I spent the whole night staring at the ceiling doing the math on the condo I had bought 4 years earlier. 1,200 square feet on the 14th floor, with a view of the North Shore Mountains. I had put down $87,000 as a down payment. I had spent another $23,000 on renovations. Every dollar came from 7 years of working as a forensic accountant at a mid-size firm downtown, spending nothing, saving everything, skipping vacations and new cars and dinners out because I had one goal, and I was not moving until I hit it. And now my brother, who had spent the last 19 months in a minimum security facility in Abbotsford for a fraud conviction, was sleeping in my bed. I want you to understand something before I continue. This was not impulsive. My aunt did not show up at my door that evening because she was desperate. She showed up because she had been planning this for weeks, and she knew exactly what she was doing. In my family, there are 2 kinds of children. There is my brother, who my aunt calls sensitive, who she says has had a hard run, who she has been making excuses for since he was 15 years old, and got caught forging checks from our grandmother's account. And then there is me, the one who figured it out, the one who left the neighborhood, got the degree, got the job, saved the money. The one who, because she figured it out, is now expected to fund everyone else's inability to do the same. 2 years before that night, my aunt called me from the hospital. My uncle had collapsed at work, a cardiac event, serious enough that they airlifted him to Vancouver General. His workplace benefits had lapsed because he had been between jobs for 8 months and let the coverage drop. The bill for the first week of treatment alone was over $31,000 for the private specialists and the procedures his provincial coverage did not fully absorb. My aunt said she did not know what to do. I wired her $31,000 the next morning, because that is what you do when family is in crisis. 3 months later, I drove out to their place in Surrey for Thanksgiving. There was a used but very clean pickup truck in the driveway that had not been there before. My uncle saw me looking at it. Your brother needed something reliable, he said, for work. Once he gets out, he is going to need to hit the ground running. The truck had cost $28,000. I know because I asked, and my aunt told me the number like it was completely ordinary. They had used the money I sent from my uncle's heart for a truck for my brother, who was still 11 months away from release. I did not make a scene. I ate dinner. I drove home. But that was the night I stopped being surprised by anything they did and started paying closer attention instead. So when I found myself on my friend's couch listening to rain hit the skylight, I was not in shock. I was calculating. The next morning I called my lawyer. She handles my real estate and some of my contract work, and she is not the kind of person who softens things for the sake of your feelings. She listened to everything I said without interrupting. Then she was quiet for a moment. Here is the problem, she said. Your brother is physically inside the unit, and he came in through a key held by someone you authorized. Under BC tenancy law, if he establishes residency, which can happen faster than people think, removing him becomes a formal process. We are talking residential tenancy branch, hearings, timelines, months, potentially. He does not need a signed lease. He just needs to be there long enough. I asked her what that meant exactly. It means they picked this on purpose, she said. Whoever advised them on this, and someone advised them, knew that a formal eviction in BC takes time, and that you would either run out of patience or run out of money fighting it and eventually settle. I asked her what settling would look like. You would pay them to leave, she said. That is what they want. A check large enough to make the inconvenience go away. And then they will tell everyone you kicked your brother out after he had nowhere to go, and you will spend the next decade being the villain at every family dinner. I hung up and sat in my friend's kitchen for a long time. Here is what most people do not understand about my family. They are not stupid. My aunt is actually quite sharp. She reads people well. She understood that I had a conscience, that I would not forcibly remove my brother in front of the neighbors, that the optics of a woman throwing her recently released brother into the street in November in Vancouver would be used against me for years. She was counting on my decency being a more powerful lever than her entitlement. What she forgot is what I do for a living. I am a forensic accountant. I find the financial lies people tell when they think no one is paying attention. I have spent 8 years reading between the lines of spreadsheets and bank records, finding the numbers that do not match the story, building the case that unravels everything. My aunt had walked into my building with 2 duffel bags and thought she was dealing with a soft target. She was not. I went completely quiet for 4 days. I did not call my aunt. I did not text my brother. I let them sit in the warmth of my condo watching my television, and thinking the silence meant I was breaking. People who believe they have won stop being careful. They get comfortable. Comfortable people do not check what is still moving underneath them. On the second day, I started pulling records. My brother's fraud conviction was public record. I already knew the basics he had been running. A small-scale investment scheme targeting people in our community. Collecting money for a renovation, contracting business that did not exist, writing himself checks from a pooled account he controlled. 14 victims. Total losses of just over $190,000. He pleaded guilty, got sentenced, served his time. What I had not looked at carefully before was the restitution order. As part of his sentencing, the court had ordered him to repay $190,000 to his victims. Restitution orders in federal criminal cases in Canada do not expire. They follow you. They are registered against your assets. And critically, if you come into money or property while a restitution order is outstanding and you do not disclose it to the court, that is a violation that can trigger enforcement proceedings and, depending on the circumstances, additional criminal exposure. My brother had been out for 3 weeks. He was now living in a $780,000 condo that, if my aunt's plan worked, she intended to have transferred into family hands either through a private arrangement, a nominal sale, or simply by occupying it until I gave up. Any asset he occupied or controlled while that restitution order was active was potentially subject to it. I pulled the court file. I read the restitution order 3 times. I called a colleague of mine who works in the financial crimes unit of a national firm and asked her, hypothetically, what would happen if someone with an outstanding federal restitution order moved into a property and a family member attempted to have that property informally transferred to family? She said, and I am paraphrasing, that the enforcement mechanisms for federal restitution orders in Canada are significantly sharper than most people realize, especially post-2019, when the legislation was updated. Creditors and enforcement bodies can move to have any arrangement that resembles asset sheltering set aside. Fraud on a restitution order is its own offense, and anyone who knowingly assists in sheltering assets from a restitution order can face civil and potentially criminal exposure. I sat back in my chair. Then I called my aunt. I let my voice go small. I have known how to do this since I was 12 years old, and figured out that being underestimated is sometimes a strategic advantage. I told her I was tired. I told her I did not want to fight the family over a condo. I said I had been thinking about it and maybe the right thing was to let my brother stay on a more formal basis, something that gave him stability while he got back on his feet. I said I wanted to make it work. I just needed to do it properly. Paperwork. Everything above board, so that no one could come after any of us later. My aunt's voice immediately warmed. That is all we were asking, she said. We just want him to have a foundation. I said I understood. I said I had been speaking with a financial advisor about the best way to structure things so that my brother having a stake in the property did not create tax issues for me, or complications for him given his background. I said there was a document I needed everyone to sign, a statutory declaration, confirming that the arrangement was a legitimate private family transfer, and that no consideration beyond goodwill was being exchanged. In Canada, a statutory declaration is a formal sworn statement made before a commissioner for oaths or a notary. Making a false statutory declaration is a criminal offense under Section 138 of the Criminal Code. My aunt said that sounded like a lot of paperwork. It is just a formality, I said. It protects all of us. She asked if my brother needed to be there. I said yes. I said the declaration required all parties present, so that everything was witnessed correctly. I said I would book the notary, cover the cost, make it easy. I said we could do it at my lawyer's office on Thursday at 2 o'clock. She said that was fine. I spent Wednesday preparing with my lawyer. We drafted the statutory declaration carefully. It stated that the signatory confirmed their participation in the private transfer of occupancy and beneficial interest in the condo unit was entered into freely and without duress, and that they had no outstanding legal obligations that would be affected by or in conflict with this arrangement. That last clause was the one that mattered. My brother had an outstanding federal restitution order for $190,000. Signing a declaration that he had no outstanding legal obligations in conflict with a property arrangement was, on its face, a false statutory declaration. We also prepared a second document, a disclosure notice drafted by my lawyer, which clearly laid out the existence of the restitution order. the legal consequences of making a false declaration, and the enforcement provisions under the Judges Act and the Criminal Code. My lawyer wanted to send it in advance. I told her not to. I told her to hand it across the table before anyone picked up a pen. Thursday at 2 o'clock. My aunt arrived first. In a blazer, she saves for occasions she considers important. My brother came in behind her in a new jacket, one I recognized from my own closet, from the box I had left in the bedroom because I had not had a chance to take it before she locked me out. He did not look at me directly. He looked at the room with the assessing expression of someone pricing what they see. My lawyer sat across from them. A commissioner for oaths sat at the end of the table. Everything was being formally recorded, not video this time, but a full written transcript by a court reporter I had hired for the afternoon. My lawyer put the statutory declaration on the table. Before we proceed, she said, I need to walk you both through the legal context of what you are about to sign. My aunt waved a hand. We understand what we are signing. My lawyer did not move. She said calmly, without drama, that a statutory declaration is a sworn document under the Canada Evidence Act and the Criminal Code of Canada. Signing one that contains false information is a criminal offense under Section 138, prosecutable by indictment, carrying up to 2 years of imprisonment. My brother shifted in his chair. My lawyer then placed the second document on top of the declaration. She slid it across the table without comment. My aunt picked it up. I watched her read the first paragraph. I watched her face go through 3 expressions in about 4 seconds. What is this? She said. Her voice had a new quality to it. Not anger yet. Wariness. That is a disclosure notice, my lawyer said. It details the outstanding federal restitution order registered against your nephew, my client's brother, in the amount of $190,000 arising from his 2022 fraud conviction. It explains that signing a declaration stating there are no outstanding legal obligations in conflict with this arrangement would, on its face, constitute a false statutory declaration. It also explains that any person who knowingly facilitates an arrangement designed to place assets beyond the reach of a restitution order may face civil enforcement action and, in some circumstances, exposure under the Criminal Code provisions regarding fraud on creditors. The room was very quiet. My aunt set the paper down. She looked at my brother. He was staring at the table. We did not know about all of that, she said. My lawyer said she understood. She said that was why we were here, to make sure everyone had full information before signing anything. My brother looked up at me for the first time since he sat down. You set this up, he said. I did not set anything up, I said. I invited you to sign a document. I am just making sure everyone in this room understands what signing it actually means. My aunt pushed back from the table. She started talking about family. She said I was doing this to humiliate them. She said after everything she had done for me, after raising me, after my parents split, after always being there, this is what she got in return. I let her finish. I know what you did for me, I said. I also know what I sent you from my savings account 2 years ago to cover Uncle's hospital bills. And I know what that money bought instead. I have the bank records. I have the timestamps. I have the transfer confirmations. I have the invoice from the truck dealership. That is not what happened, she said. It is exactly what happened, I said. And I have documented all of it because documentation is what I do. I am not doing this to humiliate you. I am doing this because you walked into my home with a plan, and I am telling you very clearly that the plan does not work. My brother stood up. He said something that I will not repeat here, and moved toward the door. The commissioner for oaths looked at my lawyer. My lawyer said quietly, professionally, that she had already notified the Federal Restitution Enforcement Office that her client's brother had recently been released and had taken up residence in a property registered to her client, and that she was flagging it as a precautionary disclosure given the outstanding order. She said this was a routine notification under her professional obligations, and that the office would be in contact with him directly regarding compliance requirements for his restitution repayment schedule, now that he was no longer incarcerated. My brother stopped at the door. What does that mean? He said. It means, my lawyer said, that now that you are released and housed, the enforcement office will begin assessing your ability to repay. They will want a financial disclosure from you. Income, assets, living situation. They will want to know where you are living, and whether the arrangement involves any property. He looked at my aunt. She looked at the table. There was no plan for this part. Their plan had a beginning, get inside the condo, and a middle, wait for Nora to fold. It did not have an end that accounted for me not folding. My brother left the room first. My aunt gathered her things slowly, not looking at me, putting on her coat with the careful movements of someone who needs something to do with their hands. At the door she stopped. You have always had to win, she said. Even as a little girl. You always needed to be the one who came out on top. I watched her. I did not win anything, I said. I bought a home, I paid for it. I let you talk me into feeling guilty about having it, and I paid for that too. I am just done paying. She left. The condo was formally vacated by the following Monday. My lawyer sent a letter that same Thursday afternoon confirming that ongoing occupancy by someone with an unresolved federal restitution order, in a property not their own, could complicate the enforcement assessment and create additional legal exposure for all parties involved. My brother was out before the weekend. The Restitution Enforcement Office did follow up. My brother was required to submit a full financial disclosure within 30 days of release standard procedure that he apparently had not yet completed, which itself created a compliance issue his parole conditions required him to address. My aunt stopped calling. I reprogrammed the building access, changed the spare key, and had a direct conversation with the concierge about authorized entry. I did not yell. I did not threaten. I simply explained that there had been an unauthorized access situation, and that going forward, no one entered my unit without a direct confirmation call to me. The concierge apologized. I told him I appreciated it and that I did not need anything more from him on the matter. I went home that Monday evening and stood in the living room for a while. It smelled like someone else had been living there. I opened the windows even though it was November and cold, and let the Vancouver air move through the rooms. I have not spoken to my aunt or my brother since. I know how this sounds to some people. I know there are those who will say I should have been more flexible, that family is complicated, that my brother had a hard road and needed someone in his corner. I have heard all of it. I heard it in my aunt's voice, my entire childhood. The suggestion that being capable meant being obligated, that having enough was the same as owing the people around you, that love without conditions meant love without limits. But love without limits is not love. It is a resource extraction strategy dressed in the language of loyalty. I have worked hard for what I have. I have made careful decisions. I have shown up for people when it cost me something real. I do not owe anyone occupancy of my home as the price of belonging to a family. And the moment I understood that clearly, the moment I stopped treating their guilt as my responsibility, the path forward was very simple. I am still in Vancouver. I am still in the condo. The view of the North Shore Mountains is the same as it always was, especially in the early mornings when there is snow on the upper peaks and the light comes in flat and clean from the east. Some mornings I make coffee and stand at the window and think about how close I came to writing a check just to make it stop. How close I came to deciding that peace was worth the price, that the exhaustion of fighting people who are supposed to love you is too high a cost to pay for being right. I am glad I did not. If you have ever had to choose between keeping the peace and keeping what is yours, hit subscribe and tell me in the comments. Would you have pushed back? Or would you have found a way to make it work? I want to know.